All right. Let me check my video. Going on there. Okay, there we go. All right, good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our misdemeanor calendar. This is the state all-purpose cases with for May 29th, 2025. This is a virtual proceeding, so I'm sure you've already read the rules with regards to how to appear in court via Zoom. I'm going to, let me see, wait for courtroom two. Good morning, Miss.
Morning, Your Honor.
Yes,
Hopefully, we have no one here yet, Your Honor.
well, okay. I understand this is going to be, you're moving on to non-complex, so congratulations, or I'm sorry, depending on the caseload, but best of luck.
Thank you.
Good morning, Deputy Francois.
PD Kim, it's been a pleasure working with you. Best of luck.
Thank you very, very much. Same to you.
Give her 3 months, she'll be back with us.
Burned out.
No, no. Give me a good old-fashioned bad DV. So. All right. Francois,
Good morning.
good morning.
I just have a quick announcement for Ms. Kim. Hey, Ms. Kim.
Yes.
So, I don't know if you want me to call you, but I wanted to know, did you need Miss Florence, position number 14? Because you have on the announcements, refused, no
Yeah.
show.
Yeah, I tried to meet her yesterday and she refused to come out to the interview booth. Is she?
I'm gonna give you a call about her. Let me call you. So you
Sure.
want me to call you in courtroom? I'll call you in courtroom too.
Sure. Thank
Okay.
you.
Thank you.
All right. Miss Falk, do we have any announcements on this calendar before we begin?
No, Your Honor, the only announcement the state has is that we have 2 cases on the competency calendar, Ms. Riles and Mr. Sullivan, where PD Bartels requested a recommendation from me. I have sent that recommendation to PD Bartels on both cases, so we may need to retain the court reporter after the conclusion of the SAP calendar to address those 2 cases if the defendants move forward with a plea.
Okay, got that.
That information to me, Ms. Falk?
I can.
Thank you.
Absolutely. Thank you, Ms. Lewis, for reminding me.
Okay, and Miss Kim, other than these cases we have on SAP, so positions 3 to 6 has been released, correct?
Yes, Your Honor.
Okay. And then position 7, Bennett, is a waiver of arraignment and further notice for trial.
Yes, Your Honor.
Okay. Let's see now. So position 14 is a possibility. Then we jump to positions 16, 17, and 18. And these are going to, 16 is a waiver of arraignment
Yes.
and further notice. 17 and 18 are also waivers and further notice.
Your Honor, I think ACDC is calling the courtroom too.
Go ahead. All right, folks, we'll be in a brief recess until the courtroom 2 and ACDC are ready. Okay, thank you. All right, Deputy, are we ready in courtroom 2?
We could start with position 1 and 2.
All right, good morning, folks. In courtroom 2, my name is Judge Law, and we're going to begin with these misdemeanor cases. These cases have already been accused, bonds have been set, and today we're going to get a status of your cases. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything that you choose to say during the course of this proceeding that's not only being live streamed but recorded, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. On positions 1 and 2, we have Killian Atabo for position number 1, 25 FTA 998. That's the bench warrant from February 24th of this year. Position number 2 with Mr. Atabo is 24 CR 6454J, accused of 2 counts of criminal trespass. Mr. Atabo, you've been advised of your right to remain silent, and your attorney is Mr. Tom White. This is going to be a plea. Is it a negotiated plea, Mr. White?
Yes, Judge.
All right. Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation on Mr. Atabo's case is on position 1, that will be a null pros upon the taking of this plea. Position 2, the criminal trespass, 12 months served 28 days, credit for time served 14 days. That is from September 11th to September 13th of 2024 and May 19th of 2025 until today. No further contact with Muriama Angelina Howard. Stay away from Road Apartment 56 in Union City. Count 2 will merge with count 1. At this time, we would like to sound for Miss Mariana Howard, and we do ask this defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Mr. White, do you so stipulate?
We do, Judge.
All right. And the location is the Rhode Island apartment complex?
I believe so, Your Honor. Let me take a moment to double check. I have Premier Club Apartments.
Premier Club Apartments, okay.
Yes.
All right. Mr. Atabo, may I place you under oath? For the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes? Speak up?
Yes.
Okay, you can put your hand down. You probably need to speak a little louder because the microphone appears to be quite distant from you, but you will need to be heard because this entire proceeding is being reported by our court reporter. All right, so have you consumed any medicine or alcohol recently?
No, Your Honor.
All right, and have you understood what's going on in your cases?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And in your conversations with your attorney, has he explained to you with regard to your waiver of rights?
Yes, Your Honor.
So you understand that if you take this plea, you would have to give up your right to a trial, to be able to go back to court, challenge the evidence brought against you, present your own defenses, and have the state prove the charges beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
How do you plead to 1 count of criminal trespass?
Yes, Your Honor.
How do you plead? Are you pleading guilty, not guilty? Or what did your attorney decide?
Yes.
Okay. On the criminal trespass charge, count 1, your sentence is 12 months to serve 28 days, credit for time served 14 days. This is going to be a balance suspended, right, Ms. Falk?
It is balance suspended, Your Honor, yes.
Okay. So the remainder of the time is suspended. So that means, Mr. Atabo, your obligations for this case is over. However, you're required to have no contact with Muriama Howard. You cannot communicate with her or be within 200 yards of her. And you must stay away from the entire Premier Club apartment complex. If you return to that location, you'll be arrested again and we get to do this all over. Understood?
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
And the bench warrant is null crossed.
Number 24, McKenzie.
This is State versus Jeremiah McKenzie. Mr. McKenzie's case is 25 CR 659E. He's accused of theft by shoplifting, willful obstruction of an officer. And Mr. McKenzie, you've been advised of your rights. Your attorney is Mr. White. And may I place you under oath for your plea?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. On position 24, the state's recommendation on the theft by shoplifting is 12 months consecutive to count 2, 40 hours of community service, an anti-theft course, stay away from the Family Dollar at 3050 MLK Junior Drive in Atlanta. On count 2, the willful obstruction of an officer, it would be time served, 224 days, credit for time served, 112 days. That is from February 6th of 2025. Just to let the court know why this case has been in custody for as long as it has, the defendant had asked for a jail jury reset back in February. I looked into why it had been outstanding for so long, and the case hadn't gone, my understanding, I don't believe he's gone to a jury trial calendar, so the case came back onto our calendar at that point.
Okay.
We
And
do ask
I'm sorry, that was 240 days.
two- 224 credit for time served, 112. And we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White?
Yes, Your Honor, we just ask to accept the plea as negotiated. We do stipulate for the purposes of the plea, and we do ask that probation terminate upon completion of his requirements.
State has no objection to non-reporting.
I'll agree to non-reporting. Mr. McKenzie, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your case?
Yes,
Are you satisfied with your attorney?
yes,
And has it been explained to you that if you decide to plead guilty to these charges, you would have to give up your right to a trial? You will not be going back to a court of law to face your accuser, challenge the evidence brought against you, present your own defenses, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
yes, Your Honor.
How do you plead to 1 count of theft by shoplifting and 1 count of willful obstruction of a law enforcement officer from February 6, 2025?
Guilty, guilty.
All right. For the count 2, willful obstruction of a law enforcement officer, your sentence is time served. Served 224 days, credit for time served 112 days. With regards to the theft by shoplifting, that's going to be a 12-month consecutive sentence to count 2, in which you will report to probation upon your release. While you in probation, you will report on Monday, which is going to be June.
Second.
Yep, you're right. It will be June 2nd, and you report to the probation office before 3 p.m.
Yes.
While you're on probation, you will complete 40 hours of community service, and you must do your community service at a minimum rate of 5 hours per month. You do that with any nonprofit agency, but it cannot be a church and it cannot be a school. You're also to enroll in an anti-theft class within 60 days of being on probation. And at all times, you have to stay away from the Family Dollar store at Martin Luther King Junior Drive. If you violate any of these conditions, you could end up having your probation revoked and serve out the rest of the year in prison. Understood?
Yes, Your Honor.
All right. Once you've completed your 40 hours community service, you have shown proof you've done the anti-theft class, and your probation fees are up to date, then your probation will be non-reporting. Thank you.
Thank you.
Thank you, Your Honor.
Position 11 and 12, Denson.
This is State versus Johnny Denson. On position 11, the case number is 24 CR 6431Y. Mr. Denson's accused of theft by shoplifting and willful obstruction of an officer from August 26th of last year. In his position 12, Mr. Denson's got a bench warrant under 25 FTA 1005. Mr. Denson, you've been advised of your rights. Your attorney is Mr. White. May I place you under oath for the plea?
Yes, ma'am.
You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. This is Mr. Denson's case.
Yes.
My apologies. I was responding to a request from one of my attorneys. So on Mr. Denson's case, the theft by shoplifting is 12 months served, 26 days, credit for time served 13 days. That will be from September 11th to September 13th of 2024. May 20th of 2025 until today. Balance probated, stay away from the Publix located at 572 Hank Aaron Drive in Atlanta, anti-theft course, 40 hours of community service, and a $500 fine. On count 2, the willful obstruction, that will be 12 months concurrent with count 1, balance probated, and a $300 fine. Upon the acceptance of this plea, the state will null pros position 12, which was the failure to appear. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White, does your client accept the terms and do you so stipulate?
We do, Your Honor, and we just ask the probation terminate upon completion of his requirements.
Your Honor, let me just take a look. I believe he may have had another theft by shoplifting. I just want to take a look before I offer an opinion on that matter.
This is position number 11.
It looks like this defendant has 24 cycles. His last arrest was in March of 2024 for financial transaction card fraud. That was subsequent to this case. Well, it looks like it was prior to this case. He did also have an Atlanta Police Department arrest in February of 2024 for theft by shoplifting. I'm not showing a disposition on that case. Prior to that, there was a 2011 entering auto case where he received 5 years of confinement. Given the number of cycles, the state would not object to non-reporting, but we would object to termination.
Have we resolved? Oh, is the other case the financial transaction? He's got an open felony case?
Correct. Let me see if I can find the, it is 24 PI 002201. It is still open. They have not indicted that case yet.
All right. And Mr. White, is he eligible for release after this plea?
As far as we understand, Judge.
Okay. I'm going to require him to go to probation every month under these circumstances. Mr. Denson, would you still like to move forward with the plea? I'm not agreeing to terminate your probation, and I'm not agreeing to put it on non-reporting. You will have to report for 12 months.
Judge,
Yes, Mr. White?
I was going to say, Judge, we're still going forward.
No. Say yes, ma'am.
All right, Mr. White, did you have anything else to add?
I just said we are still going forward, Judge.
Okay, got it. All right, Mr. Denson, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Are you entering this plea freely, willingly, and voluntarily?
Yes, ma'am.
And you understand that if you accept this plea offer, you would have to plead guilty to these charges. And if you have 3 or more theft by shoplifting convictions on your record, the 4th possible arrest will be a felony charge.
Yes,
Has that
ma'am.
been explained to you?
Yes, ma'am.
Okay. If you decide to plead guilty, you would have to give up your right to a trial. You will not go back to a court of law to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting and one count of willful obstruction of a law enforcement officer?
Guilty.
On the shoplifting conviction, your sentence is going to be 12 months to serve 26 days, credit for time served 13 days. If you have no other holds, you'll be released within 24 hours, but you must report to Fulton County Probation on Monday, June 3rd, before 3 p.m. While you are on probation, you will complete the following. You will at all times stay away from the Publix on Hank Aaron Drive. You will complete 40 hours of community service at a minimum rate of 5 hours per month at any nonprofit agency that's not a church and not a school. Within 60 days of being released, you will enroll in an anti-theft class and complete that class. And you will pay a $500 fine at a minimum rate of $50 per month. On the willful obstruction, it's going to be 12 months concurrent to count one with an additional $300 fine. So your total fine for this case is going to be $800 plus court costs and probation fees. With regards to the fine, you must make a minimum payment of $80 per month. Understood?
Yes, ma'am.
All right. You will report to probation every month until the remainder of your 12 months is completed. Thank you.
Good morning, Judge. I have position number 37 and 38, Ms. Wallace Shields.
Okay.
Just FYI, she is cuffed to the back.
I'm sorry. Repeat that, Deputy Francois.
I just said FYI, she is cuffed to the back, so she's not going to be able to raise her right hand.
Understood. Thank you. This is Brianna Shields Wallace. Ms. Wallace has a misdemeanor matter obstruction of a law enforcement officer under 22 CR 000374J from January 26th of 2022. She also has a bench warrant from October 24th, 2022, and her bench warrant is 25 FTA 996. This is going to be a plea. Ms. Kim, will you be representing her?
Yes, Your Honor.
All right. Ms. Shields Wallace, do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Okay.
Yes.
Ms. Falk, what is the plea offer for Ms. Shields Wallace?
Yes, Your Honor, this is a time-served plea. The defendant has been in custody for 32 days. We are giving her credit for 16 days. Well, she's been in custody for 16 days, so it is 32 credit for time served 16 from January 26th to January 27th of 2022 and May 16th, 2025 until today. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea, and we will enter a null pros on position 38 upon the acceptance of this plea. That's all for the state.
Ms. Go ahead.
Yes, we do stipulate for the purpose.
Ms. Shields Wallace, have you consumed any medicine or alcohol recently?
No, just medicine, but not any alcohol. Huh?
After consuming it, are you still able to understand your attorney and what's going on right now?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to plead guilty to the willful obstruction of an officer, you would have to give up your right to a trial. You will not go back to a court of law to face your accuser, challenge the evidence brought against you, present your own defenses, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights? Repeat.
Yes, ma'am.
How do you plead to one count of obstruction of a law enforcement officer?
Guilty.
Okay. Your sentence is going to be time served to serve 32 days, credit for time served 16 days, and the bench warrant is dismissed. That completes your cases. Thank you.
Sir, come on, let me do it. Let me go. Position number
32.
Thank you. All right.
This negotiated plea, except only one thing, that restitution to the deed. We would like to object to the restitution since we have been waiting for any receipts for last 129 days.
All right. And so we are amending this from a bond hearing to a plea.
Yes, Your Honor.
Antoine Parker is accused of criminal damage to property from October 11th, 2024 in case 25 CR 2880E. Mr. Parker, you've been advised of your rights to remain silent, and your attorney is Ms. Kim. May I place you under oath for the plea? Do you
Yes, ma'am.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. This is going to be deemed a non-negotiable plea since there seems to be an issue with one of the requirements of restitution. Ms. Falk, what's your state's recommendation?
Yes, Your Honor. On the case on the calendar, we are asking for 12 months served, 258 days, credit for time served 129 days. That would be from October 14th to December 13th of 2024 and March 21st of 2025 until today. Balance probated, no further contact with Broadus Butler. Stay away from 3 Joseph E. Lowry Boulevard in Atlanta. We are asking that restitution be held open for 30 days and 40 hours of community service. The add-on case, which is 24 CR 0006424E, count 1, the DUI would merge with count 3. Count 2, the DUI would merge with count 3. Count 3, the DUI, will be 12 months served, 140 days, credit for time served 70 days for
Oh.
March.
I'm sorry, that case is not on my calendar. I don't have the state's recommendations.
Oh,
So if we could just slow it a tad, please. So I have.
I will. My apologies. I don't know how it got deleted. It was right under the main recommendation, so I apologize.
No. I just got the clerk's calendar. I don't have yours. So
Oh, I will forward you mine, Your Honor.
in the meantime, it was 24 CR 006
0
4E.
6424E. Yes.
And what were the charges? DUI?
DUI, 3 counts. Count 1 and count 2, DUI will merge with count 3.
Okay,
The third count of DUI, which is the less safe,
correct?
will be, let me just make sure that is less safe, will be 12 months, serve 140 days. He'll receive credit for 70 days. And that will be from March 21st, 2025 until today. It will be balance probated,
Okay.
ADET,
Mhm.
DUI risk reduction, $1,000 fine, 40 hours of community service, and there's going to be 2 victim impact panels. Count 4 will be time served. Count 4 is marijuana possession less than 1 ounce.
Mhm.
That will be time served. Count 5, the possession of open alcohol container would be, and there is a mistake on that one, Your Honor, that will just be a $200 fine.
Okay.
You don't have the calendar, but I'm just amending that, which is lower than what it originally would have been. And on the last count, the equipment violation, that will be 12 months concurrent with count 3 and a $135 fine. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. And just to put on the record, count 3, the main count he is pleading to is DUI under the influence of a combined alcohol and drugs.
Okay. The restitution, that was for,
That is for the case on the calendar, the criminal trespass.
all right. And what's the reason why we are seeking restitution almost 4 or 5 months later?
So the reason we are seeking restitution at this time, this was a case that was transferred from the DA's office. It wasn't received by our office until May 19th. So quite frankly, the defendant may have been in custody this amount of time. The state court has had this case for 10 days. So we are asking for 30 days in order to get in touch with the victim and determine the restitution that is outstanding.
All right, Miss Kim, under these circumstances, what is the objection to keeping the case open for 30 days for the state to address restitution? And of course, if y'all object to restitution, there can be a hearing about it. But if past 30 days, if they don't provide an amount, then that matter is moot.
Okay, do you want to argue about it or do you want to open 30 days restitution? Is it gonna be okay?
And Your Honor, the other option is the court can continue this case to next week and we'll have time to get in touch with the victim.
Oh, actually, he is fine with restitution for 30 days open.
Okay, and the restitution will be capped to less than $500 because this is a misdemeanor charge.
Yes, Your Honor.
And also, Your Honor, he is currently unemployed. He's been incarcerated for more than 70 days.
Mhm.
He has to look for a job and he has to start his life all over again.
Yes.
So we would like to request that those fines to be converted to community service and first 2 months of probation fees to be waived.
I will waive up to 5 months of probation fees, but you'll have to pay the fines.
Thank you.
And Your Honor, just to let the court and the clerk know, there is an open FTA on his 24 CR case. So the state is entering a null process as to that case upon the acceptance of this plea.
Does it have a separate case number?
It does. It is 25 FTA 000614.
Okay. Miss Kim, is your client agreeing to the matter regarding restitution?
Yes, he does.
So, Mr. Parker, have you consumed any medicine or alcohol recently?
No, ma'am.
And I know it's a little convoluted because you have 3 open cases, including a bench warrant. But have you gone over the issues with your attorney, and do you understand what's going on in your cases?
Yes, ma'am, that she's saying that we can, with your permission, with your permission allow that I be able to go to community service to do the proper amount of
No,
hours.
sir, I denied it.
Oh,
I denied the community service. You would need to pay, you would need to get a job to start paying
Okay.
your fine.
yes, ma'am. Yes,
But
ma'am.
I waived your probation fees for the
Yes,
first
ma'am.
5 months.
Yes, ma'am. Yes, ma'am. Yes, ma'am. And I will be sure to get a job, and I'll be sure to stay out of trouble and stay off that street. And I will not be visiting that street ever again. And I will get a job, and I will do what I'm supposed to do as a good citizen of this United States of America. And I will literally abide by the law.
Do you own a car?
No, ma'am, I do not own a car.
Be driving for the next 12 months either. Do you understand?
Yes, ma'am. I will not drive for the next 12 months either.
And let's go through this then. Okay, so you are satisfied with your attorney services?
Yes, Your Honor. Yes, yes,
No, it's just a yes or no.
yes, ma'am.
All right. And has your attorney explained to you a waiver of your rights if you decide to move forward with this plea?
Yes, ma'am. Yes, ma'am.
So you understand that if you decide to plead guilty to the 2 cases pending before you, that you will not have the opportunity to go back to court and have a trial in either or both cases. You will not be able to have your attorney help you to confront your accuser, challenge the evidence brought against you in both cases, be able to present your own arguments and legal defenses, and the prosecutor will have to prove her burden of carry her burden of proving all these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Like I said,
Yes, sir.
yes, ma'am. May I ask one more thing?
You can ask me.
Oh, may I ask? I'm sorry.
Thank you, Your Honor.
All right. All right, in that case, since he has acknowledged a waiver of his rights, Mr. Parker, how do you plead to one count of criminal damage to property from October 11, 2024 in case 25 CR 2880E?
Guilty.
Your sentence for the criminal damage to property is going to be 12 months to serve 258 days, credit for time served 129 days, balance probated, at which time you are to have no further contact with Mr. Butler, and you are to stay away from 3 Joseph E. Lowry Boulevard. Your case will still remain open for the issue, or the sentence will still remain open for the issue of restitution. If the state does provide a valid figure estimate for the alleged damage, the alleged amount of restitution cannot be more than $500. With regards to your second case, 24 CR 006424E, how do you plead to one count of DUI less safe? Just a minute. One count of misdemeanor possession of marijuana, one count of open container of an alcoholic beverage, and one count of a vehicle equipment violation. Ms. Kim, if further discussions are required, I can address this case later in the calendar.
No.
Yes, Your Honor.
Okay, so,
He says he's fine, Your
Yeah,
Honor.
we're fine.
all right.
Yeah.
Yeah.
What we talking about? Yeah, with the stimulation that we've already spoke about, I'm willing to agree, take the responsibilities of what.
Stop talking and start listening. Otherwise, I'll wait till next week to address your case.
My apologies.
Listening now?
Yes, ma'am.
All right. So in your second case, 24 CR 006424E, that's your DUI case. How do you plead to
Good.
DUI? How do you plead to DUI less safe? Possession of marijuana less than 1 ounce, possession of an open container with an alcoholic beverage, and equipment violation.
I'm guilty.
Count 1 and 2 will merge into count 3, which is the DUI less safe charge. The sentence is going to be 12 months to serve 140 days, credit for time served 70 days. The balance will be probated. While you're on probation, Mr. Parker, you will complete an alcohol and drug evaluation and submit yourself to any treatment with any healthcare provider. You will complete a risk reduction program, and the alcohol and drug evaluation and the risk reduction program, you must undertake these 2 programs within 60 days of being released. You will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and a school, and you will do your community service at a minimum rate of 10 hours per month. You will also complete 2 victim impact panels. You will attend 2 victim impact panels seminars or presentations. You will also pay a $1,000 fine for the DUI charge. Like I said, I will waive your probation fees for the first 5 months, but you'll need to get a job and start paying your probation fees. You must, your fine. And your fine, you must start paying it in the 3rd month of your probation at a minimum rate of $200 per month.
No, that's it.
Open alcohol container, your fine is going to be a $200 fine. For the equipment violation, is going to be 12 months concurrent with count 3, and there's an additional $135 fine. For the possession of marijuana is going to be a time served charge of 70 days. Well, yeah, time served would be time served of 140 days, credit for time served 70 days. That's for the misdemeanor possession of marijuana. And for your third case, the bench warrant 25 FTA 000614, that case is dismissed. Thank you.
Thank you. Thank you.
I have position number 8, Ms. Daniel.
Romeda Daniel is accused of theft by shoplifting from May 12th of 2025, case 25 CR 2698C. Ms. Daniel, you've been advised of your rights. Your attorney is going to be Ms. Kim. And may I place you under oath? Raise your right hand, please.
Before you rush me, it's more nervous on you.
Ms. Daniel, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Repeat.
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on Ms. Daniels' theft by shoplifting case is 12 months, served 30 days, credit for time served 15 days. That will be from May 15th, 2025 until today. Balance probated, 40 hours of community service, stay away from the Walmart located at 844 Cleveland Avenue Southwest, an anti-theft course, and a $500 fine. I will state that Ms. Daniels has 8 prior arrests, including 1 prior arrest for theft, 2 prior arrests for theft by shoplifting, and 1 prior conviction for theft by shoplifting. 2 prior convictions for theft by shoplifting. For that reason, the state would not agree to, would ask that the judge, that Your Honor, not give early termination or non-reporting as part of probation. That's all for the state.
Ms. Kim?
Yes, Your Honor. Could we ask $500 fine to be converted to 50 hours of community service? My client is actually self-employed doing house cleaning, and it would be very hard for her to come up with a cash.
And Your Honor, I just want to point out that she is already with the state's, part of the state's agreement is 40 hours community service. So this would make a total of 90 hours community service. We also ask the defense to stipulate to venue, factual basis, and identification for the plea.
Yes, we do stipulate.
All right. I'll reduce the fine to $300 and convert to $200 to an additional 20 hours. So it will be 60 hours of community service, and the $500 fine would be $300. Would you still like to move forward?
Yes.
Okay. I will waive for probation fees for the first 2 months. Ms. Daniel, I'm sorry, Ms. Kim, you so stipulate that?
Yes, we do, Your Honor.
Ms. Daniel, have you consumed any medicine or alcohol recently? You'll need to speak up clearly so I can hear you.
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Speak up, please.
Yes, ma'am.
Has your attorney explained to you that if you plead guilty today, this will be your 3rd shoplifting conviction on your record, and that any future arrest for shoplifting will be a felony charge?
Yes, ma'am.
Are you still willing to move forward with this case?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your right to a trial. You will not be able to go back to court to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights? I can't hear you.
Yes, ma'am.
How do you plead to one count of theft by shoplifting from May 12th at the Walmart?
Guilty.
Repeat.
Guilty.
Your sentence will be 12 months to serve 30 days, credit for time served 15 days. If you have no other holds, you should be released within 24 hours, but you must report to Fulton County Probation on Monday, June 3rd, before 3 p.m. While you're on probation, you are to stay away from the Walmart at 844 Cleveland Avenue. Just for your information, most likely you'll be required to stay away from all Walmarts because they will have your picture with their theft prevention team. You are to enroll in an anti-theft class within 60 days of being on probation. You will complete 60 hours of voluntary community service at a minimum rate of 10 hours per month. You can do that at any nonprofit agency, but it cannot be a church and it cannot be a school. You will also pay a $300 fine at a minimum rate of $50 a month. Your probation fees for the first 2 months will be waived, but you'll be required to report to probation every month. Thank you. Right, Francois? Okay.
Let's do 27 and 28 Mosley.
This is State versus Eric Mosley, accused of willful obstruction of an officer from February 18th of this year, 25 CR 1079F. Mr. Mosley also has a bench warrant from April 2nd of this year, 25 FTA 1002. Mr. Mosley, you've been advised of your rights. Your attorney is going to be Mr. White. May I place you on the oath for the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Your Honor, on position 27, we are requesting, the state is asking for time served 28 days, credit for time served 14 days. That will be from February 28th, 2025 till March 2nd, 2025, and May 19th of 2025 until today. On position number 29, which is the FTA, the state will enter a null pros upon the acceptance of the plea on position 27. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White, do you so stipulate?
Yes, Your Honor.
Mr. Mosley, have you consumed any medicine or alcohol recently?
Consumed any? Concealed any or consumed any?
Did you take any medication in the last 24 hours?
Yes, ma'am.
Are you still able to understand what's going on?
Yes, ma'am.
Are you satisfied with your attorney?
Yeah, he said I get to go tonight or tomorrow morning.
You'll be released within 24 hours unless you've got any other cases holding you. But right now, I need to know if you're satisfied with your attorney services.
Yes, Your Honor, yeah,
If you decide to plead guilty to the obstruction of an officer charge, you would have to give up your right to a trial. You will not go back to a courtroom to face your accuser, challenge the case against you, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
yes, ma'am.
How do you plead to one count of willful obstruction of an officer?
One that gets me out 24 hours if I just plead guilty.
Are you pleading guilty?
Yes, ma'am.
Your sentence is going to be to serve 28 days, credit for time served 14 days. That closes your case out and your bench warrant's dismissed. Thank you.
So I
Thank
get
you, Your
out in the next 24 hours?
Yes, yes.
Your Honor, he should. He has nothing else holding him except for this FTA.
Crossing fingers and toes. Okay. Next case, please. ACDC.
Position number 48, Wilkerson.
This is State versus Shankaria Talisa Terrier Wilkerson, accused of criminal trespass from May 15th of this year, case number 25 CR 2761E. Ms. Wilkerson, you've been advised of your rights. Your attorney is Ms. Kim. May I place you under oath for the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes.
You may put your hand down. Ms. Falk?
Yes, Your Honor. Which position is this? My apologies.
48, the last one.
48. Thank you, Your Honor. On position 48, Shankaria Wilkerson, the criminal trespass charge, the recommendation is 12 months served 28 days. Credit for time served 14 days. That will be from May 15th of 2025 until today. Balance suspended. Stay away from the Walmart at 4735 State Route 138 in Union City. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Ms. Kim, do you so stipulate?
Yes, we do, Your Honor.
Ms. Wilkerson, have you taken any medicine or drunk any alcohol?
No.
And have you understood what's going on in your case?
Mhm.
All right, you'll need to say yes or no. Have you understood
Yes.
what's going on in your case? All right, we can take her case next week when she doesn't have the giggles anymore. Are you ready to be serious?
Okay. I'm listening.
Oh. Oh,
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to criminal trespass, you would have to give up your right to a trial. You will not go back to a court of law to face your accuser, challenge the evidence brought against you, and the prosecutor won't have to prove the charge against you beyond a reasonable.
Okay.
oh.
Okay.
How do you plead to criminal trespass? Do you understand the question?
Yes.
How do you plead to one count of?
Guilty.
Okay. Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days, balance suspended. You are not to return to the Walmart store at 4735 on State Route 138 in Union City. At this time, I recommend you do not return to any Walmart store for the rest of your life. Thank you.
Okay.
All right. Well, now she can go and giggle to her heart's content.
Position number 13.
13? Okay. All right, Mr. White, are we still proceeding with a bond hearing?
Yes, at this time, Judge.
All right. Just FYI, this is Devonte Irvin, case number 25 CR 002-431H. He's scheduled for an arraignment with Judge Taylor on July 15th. So if you decide to file, if you want me to arraign the case today or file waiver arraignment, that's up to you, but let's proceed with the bond hearing first. Mr. Irvin, you've been advised of your right to remain silent. Your attorney is Mr. Tom White. You have the following charges against you: 2 counts of battery family violence, 2 counts of simple battery family violence, and 1 count of criminal trespass. You've had your first appearance and a bond of $6,000 split bond was issued against you, in which $3,000 was a cash bond only, and the other portion of the $3,000 is a signature bond through pretrial level 3. I understand that Mr. Irvin has got 14 arrest cycles. Miss Roberts?
Yes.
All right. Can you confirm that GCIC?
Give me 1 second to pull it up, please.
Position 13 on the calendar.
Okay. Judge, did you say 14 arrest cycles?
I thought it was 14, 1-4. At least that was,
Yes.
okay. Let me see. All right. Anything else? Ms. Roberts, does he have any open cases with us or in any other jurisdiction?
Let me double check Odyssey for the additional open cases with us. And our SharePoint is moving really slow where we share our criminal histories.
I didn't see any. I was just wondering if he had any in any other jurisdiction.
Double check our SharePoint is moving slow, so the pages aren't loading.
Your Honor, this is the only case that I'm seeing in the state of Georgia. All of the other previous cases that I'm showing are out of North Carolina.
Okay. And Mr. White, what's the reason for the bond modification?
Your Honor, we're asking that the cash bond be converted to a surety bond. 14 arrests, I understand that, but he has none in the state of Georgia. My understanding is that he has no violent arrests as well. But prior to being arrested, he was working 2 jobs. There is a stay away and a no further contact with the alleged victim. We have no problem with that. He has an aunt and a cousin in town that he can live with. And we're just asking that this be converted. He's now been in jail 22 days at this point, obviously is unable to make that bond. And I think converting it to surety bond and giving him an opportunity to possibly make bond is fair.
Ms. Falk?
Yes, Your Honor. I think the state's concern is although the victim initially she has vacillated and stated she no longer wants to prosecute, but initially when the defendant was arrested, she stated that the defendant choked her. She stated she was able to breathe and did not think she was going to pass out, but she was scared. She was screaming for help when the defendant pushed her on the bed, placed a pillow on her face to stop her from screaming. She stated that this was not the first time the defendant had been violent toward her, but the first time the police had become involved, and that she did not want him to return to the residence and needed a one-time police escort. Additionally, the defendant, I believe the cash bond was issued because the defendant's ties to this community are fairly tenuous if you were going by his history. His last case was actually in 2021. He was incarcerated in the North Carolina Correctional Facility in 2021. That was based on a breaking and entering, which was about 6 counts of breaking and entering, where he was sentenced on that case. He also had a larceny of a firearm. Let's see. More breaking by entering charges that were disposed of in 2021. And it looks like there were several cases that stemmed from breaking and entering of motor vehicles and larceny of firearms. And he was sentenced to prison as a result of that, as well as financial transaction card theft and a possession of a stolen firearm back in 2021 as well. So what I'm seeing is a fairly, and possession, if I may finish, and possession of a firearm by a felon in 2021 as well. So I would believe that the reason for Your Honor issuing a $2,000 cash bond is due to his very tenuous relationship with this state. We also are concerned about the risk to the victim in this case, and we are asking that that bond remain as set. The defendant has been in prison multiple times, and I believe that would also be a concern for risk of reoffense given his history. That's all for the state.
Anything else to add, Mr. White?
Your Honor, just that the last arrest was 4 years ago, and it sounded like we were dancing around a bunch of different charges from 1, maybe 2 cases. He does have ties to the community. He will be living with his aunt and cousin who do live here in the Atlanta area. Again, he was working 2 jobs prior to this. Our information is that the alleged victim does not want to press charges in this case. She's written an affidavit as such to the state And of course, we understand that it is not her decision to go forward with the case, but in order to prosecute, but in order to get a conviction, they do need her cooperation.
Understood.
And we have personally served her, Your Honor, so whether we have her cooperation or not, she has been ordered to come to court.
Mhm. So I was the one who set the bond, and his multiple history of theft-related issues is not the pivotal factor. The pivotal factor seems to be what the victim allegedly reported to the officer initially. And I stated this at first appearance, and I'm saying it again. I don't know why this is not a felony case.
Well, these are mere allegations at this point, Judge.
Understood. I'm not here to upgrade the charges. I'm just here, I'm seriously questioning it based on allegations in the warrant where the victim was alleged, her head was banged against the bed frame, punched in the face, and a pillow was forced over her face where he was screaming at her to pass out. She presented to the officer with multiple injuries to her face, neck, nose, upper lip, and bruising to her left upper arm. These are serious, serious injuries and serious allegations that are tantamount to what I think is a felonious act, but that's up to the district attorney's office. I will grant the the defense request and amend the cash bond portion to a surety bond portion. So it will be a $3,000, a $6,000 split bond. And once he makes that bond, he will be equipped with an ankle monitor for the minimum period of 6 months. Monitoring fees are to be paid by him. I want to make sure that he stays away from Miss Jasy Anna Alacron, and that he stays away from the location 820 West Marietta Street Northwest. This is going to be a minimum period of 6 months, and that's going to be a requirement of his surety bond. Once he makes bond and he's equipped with the ankle monitor, then the signature bond portion kicks in, and he'll be required to report to pretrial once a week, enroll in a domestic violence intervention program, and all the other conditions remain the same. I'm going to grant it because he's been in custody for 2 weeks, but I hope he takes this matter seriously, because if he gets arrested again for anything else, I don't have any problem putting him in a no bond status until the day he goes to trial.
Fair enough, Judge. And I'll be filing a waiver, and I'll speak with him, make sure he understands what's going on.
Your Honor, what is the breakdown of that $6,000 split bond?
Okay, so it was, let me go back to the original bond order. I think it was this one.
Okay, I see it, Your Honor. It looks like it was a $2,000 cash bond, which I understand you're converting to a $2,000 surety bond, and then $1,000 level 3 pretrial services bond on the remaining 4 charges.
Correct. So count 1 and 2 will be a $2,000 surety, and count 2 would be a $1,000 surety. With the ankle monitor requirement, all other conditions remain the same.
So 3,000 surety, 3,000
signature bonds with pretrial.
signature.
Level 3.
Thank you, Your Honor.
Okay. And this is going to be a waiver of arraignment. So once he makes bond, Mr. Irvin, I need to let you know that on July 15th, you have a court appearance before Judge Wesley Taylor in the State Court of Fulton County. Immediately upon your release, you are to make sure that we have your new address with the clerk's office, and that you put down on your calendar your next court date with Judge Taylor. Even though your attorney is filing a waiver of arraignment, I highly recommend that you appear in order to avoid a bench warrant being issued against you.
June or July, I'm sorry.
It's, did I say June? I'm so sorry. I meant July. It's July 15th, 2025 at 10 a.m., courtroom 3E.
Yes, ma'am, thank you.
All right, good luck.
Excuse me, Judge Law, regarding to the bond amount, for the ankle monitor, is that gonna be paid through him or how is that gonna be paid?
Defendant, he'll be paying the monitoring fees for 6 months.
Judge, I have position number 17, Hillard. But before we move forward with that position, Judge, I do have a quick announcement for position number 14, Florence.
Yes,
That's gonna be a, 14, Florence, that's gonna be a medical reset.
all right. Position 14, I think is Candiger Florence.
Florence,
That-
that
yeah,
is correct, Judge.
reset to next Thursday. And,
To competency calendar, Your Honor, please.
oh, okay. So that will be reset to next Thursday at,
11 a.m.
yeah.
Mr. Irvin?
Do we need a social worker visit at this time?
I believe they already visited. Yes.
All right,
Okay.
okay. So that will be June 5th.
Yes, Your Honor.
Is she gonna be, she's placed on the competency, correct?
Yes.
Okay.
All right, who do you have, Deputy Francois?
This is position number 17, Hillard.
This is waiver of arraignment, Your Honor. So actually, we do not have to have her.
This is Maya Hilliard.
Yes.
All right, Ms. Hilliard, your case number is 23 CR 410J. Your attorney is Ms. Kim, and she has entered a not guilty plea on your behalf, and your case will be further noticed for trial. This will also include your bench warrant 25 FTA. I think it's 995. All right. That concludes the case with Ms. Hilliard.
Number 7, Bennett.
This is also waiver of arraignment as well, Your Honor.
Keandre Bennett, is that correct?
Yes, Your Honor.
All right, Keandre Bennett's accused of giving false information to an officer. Case number 25 CR 1897B. And I understand that Mr. Bennett, you've been advised of your rights. Your attorney is Ms. Kim, and she has filed a not guilty plea on your behalf. So your case is going to be further noticed for jail jury. Does he have any other matters, Ms. Kim?
No, Your Honor.
He does.
Oh, he does. Mr. Tom,
Yeah.
actually.
All right, wanted to be. All right, thank you.
Thank you, Judge.
Number 15, Gay.
Dominic Gay is accused of criminal trespass and misdemeanor possession and use of a drug-related object from May 7th of this year. Case number 25 CR 2396C. Mr. Gay, you've been advised of your right to remain silent. Your attorney is Mr. White. May I place you under oath for your plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up. You need to speak up to say yes or no.
Yes, ma'am.
Thank you. All right, Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation on this on count 1 is 12 months served 60 days, credit for time served 22 days from May 8th, 2025 until today, balance probated ADET. On count 2, the criminal trespass, 12 months to serve 60 days, credit for time served 22 days from May 8th, 2025 until today, balance probated. Stay away from the Valero located at 1980 Delow Drive, Southwest in Atlanta. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. We are agreeable to non-report after he completes the ADET. That's all for the state.
Mr. White, do you so stipulate, and does your client accept the terms?
Yes, Your Honor.
And you understand he has 8 more days to serve at the jail?
Yes, Judge.
Okay. Ms. Gay, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, can I ask a question?
Sure.
So I will not be getting time served today?
No,
Mr. Day, we discussed this ad nauseum. All right, you have 8 more days.
All right.
so, Mr. Gabe, are you still willing to move forward with this plea?
Yes, ma'am.
So, have you any other questions, or do you now understand what's going on in your case?
Yes, I understand.
Are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to these 2 charges, you would have to give up your right to a trial. You will not go back to a court of law to face your accuser, challenge evidence that will be brought against you, have your attorney help you to present your arguments and defenses, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of possession and use of a drug-related object and 1 count of criminal trespass?
Yes.
For the possession of a drug-related object, your sentence is going to be 12 months to serve 60 days, credit for time served 22 days. Balance probated. You will report to probation on Monday, June 2nd, before 3 p.m. And while you're on probation, you will undergo an alcohol and drug evaluation and submit to any treatment that's required. This must be done within the first 30 days of being released. I'm sorry, you won't be reporting to probation on June 2nd. You'll report probation within 48 hours of being released from the jail. So you have 8 more days to serve. And then after that, within 48 hours, you report to probation. Understood?
Yes, ma'am.
Okay. For the criminal trespass, it will be 12 months to serve 60 days, credit for time served 22 days, concurrent to count 1. And once you are on probation, you are to stay away from the Valero gas station at 1980 Below Drive. And once you have completed the alcohol and drug evaluation and any treatment that's required, you're up to date with your probation fees. Your probation will be non-reporting. But even while you are non-reporting, you're required to stay away from that Valero gas station. Thank you.
Position 22 and 23, Lampage.
This is Amarj Dominic Lamp, case number 23CR752H. And he's got a bench warrant 25 FTA 1011. Mr. Lamp, you've been advised of your right to remain silent. Your attorney is Mr. White. For your initial case, you do have 7 misdemeanor charges: driving under the influence of alcohol less safe, driving under the influence of alcohol per se, failure to have license on person, possession of an open alcohol container, failure to signal lane change, disorderly conduct, and failure to maintain lane change or improper lane change. How are we proceeding, Mr. White?
It's going to be a plea, Judge.
All right. Mr. Lamp, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Falk?
Yes, Your Honor. On count 1, the DUI less safe, it is going to be 12 months served 20 days, credit for time served 10 days. That will be from March 29th to March 30th of 2024 and May 22nd, 2025 until today. Balance probated, a $500 fine, 40 hours of community service, DUI risk reduction, ADET, and a victim impact panel. Count 2 will be null prost, that is the DUI per se. Count 3, the failure to have license on person, a $210 fine, concurrent with count 1. Count 4, the possession of open alcohol container, a $200 fine, concurrent with count 1. Count 5, the failure to signal lane change or turn, will be null prost. Count 6, the disorderly conduct, will be 12 months probation, concurrent with count 1. And count 7, the failure to maintain lane, will be null prost. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Mr. White, do you so stipulate?
We do stipulate, Your Honor. Just ask you to accept the plea as negotiated. We are also asking for a certificate of first conviction, and that his probation go to non-reporting once he completes all of his requirements.
All right. I'll grant the certificate of conviction. He'll need to go, once he's released, he'll need to take his driver's license to the clerk's office and request the certificate of first conviction, which will then have to be signed by a presiding judge before he can take it to DDS. Do you understand, Mr. Lamb?
My license was taken
Yeah,
already.
Yeah, just go to the clerk's office. You know what? When you're done, have a deputy have them call me, and I'll explain it all to you. Okay?
Okay.
Okay.
And Ms. Falk, any objection to non-reporting?
No objection to non-reporting once he's completed the conditions.
All right. I'm going to include something else, which is going to be random screens for alcohol and illegal drugs. So whether you are on reporting or non-reporting probation, you'll be subject to rent. So a probation officer could call you to tell you to go take a screen test for alcohol or illegal drugs, because you're not allowed to consume any of that stuff while you're on probation. Do you understand, sir?
Yes.
Okay. And I'm sorry, Mr. White, you so stipulate. Okay. Miss. Okay, thank you. I think he's driving. I think Mr. Thomas is driving. So if you can put him in the waiting room, he needs to pull over before he can be allowed back in the main session. Thank you. All right. Mr. Lamp, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your DUI case?
Yes.
And are you satisfied with your legal services?
Yeah.
All right. In your conversations with your attorney, has he explained the waiver of rights?
Yes.
So you understand that if you decide to plead guilty to these charges, you would have to give up your right to your right to a trial. You will not go back to court to have a trial before a judge or a jury, to be able to confront your accuser, challenge the evidence that will be presented against you, be able to present your own defenses and arguments through your attorney, and have the state carry its burden to prove all charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering this plea freely, willingly, and knowingly?
Yes.
All right. So you understand that your license upon this conviction will be suspended. I'll grant you a certificate of first conviction, but you will need to go to the clerk's office to get the paperwork squared away in order to present to the Department of Driver Services. Do you understand that?
Yes.
Okay. How do you plead to the following 4 charges? Driving under the influence of alcohol less safe, failure to have license on person, possession of an open alcohol container, and disorderly conduct.
Guilty.
For the DUI less safe, your sentence is 12 months to serve 20 days, credit for time served 10 days. The remainder of the time you'll be placed on probation. If you have no other holds at the jail, you'll report to probation on Monday, June 2nd, before 3 p.m. While you're on probation, you will complete an alcohol and drug evaluation and submit yourself to any treatment, and you will complete a risk reduction program. These 2 items must be completed within the first 60 days of being on probation. You will pay a $500 fine for the DUI charge. You will complete 40 hours of community service at a minimum rate of 5 hours per month with any nonprofit agency that's not a church and not a school, and you will attend and complete 1 victim impact panel. For the failure to have license on person, the sentence is going to be a $210 fine. For the possession of an open alcohol container, that's going to be concurrent with count 1 with the addition of a $200 fine. For the disorderly conduct, that's going to be 12 months probation, concurrent with count 1. And so You are pleading guilty to 4 charges. The DUI per se is null crossed, and the failure to signal lane change is null crossed, and the failure to maintain lane is null crossed. Your total fine is going to be $910 plus probation fees and court costs and other service fees. You will pay your fine at a minimum rate of $100 per month. Once your fines and all costs are paid up, your probation fees are up to date, and all the conditions have been completed for the DUI case, DUI conviction, then your probation will be non-reporting. At all times, whether you are on active or non-reporting probation, you're not to consume any alcohol and you're not to consume any illegal drugs. You will be subject to random screens by your probation officer. Thank you.
Thank you, Your Honor. Hey, Blunt, can you stick him on the phone and I'll call?
Okay,
Thank you.
number 4243, Thomas.
42, 43. Okay. And for Mr. Lamp, his bench warrant is null crossed. Anthony Leonard Thomas has got 2 cases before us, 24 CR 4880J, accused of DUI less safe, DUI per se, and driving on a canceled or suspended registration. And his second case is 25 FTA 1000, and that's a bench warrant. Mr. Thomas, you've been advised of your right to remain silent, and your attorney is Ms. Kim. May I place you under oath, Mr. Thomas? You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
And Ms. Falk?
Yes, Your Honor. On count 1, the driving under the influence of alcohol less safe, the state's recommendation is that that count merge with count 2, which is the driving under the influence per se count. On count 2, the state's recommendation is 12 months, serve 90 days, credit for time served 12 days. That is from May 18th of 2025 until today. Balance probated, a $1,500 fine, 480 hours of community service, ADET, DUI risk reduction, 2 victim impact panels, and we are requesting an interlock device. On count 3, the driving on a suspended license, we are requesting 90 days, credit for time served 12 days from May 18th, 2025 until today, concurrent with count 2. As you can see, from the recommendation, this defendant has previous DUI convictions and also, I believe, has 1 pending DUI case, which is the reason for the state's recommendation. He is very close to becoming a habitual violator at this point.
Okay.
And so we do ask that this his probation not terminate or go non-reporting upon the completion of these conditions. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. Upon the acceptance of this plea, we will enter a null process to position 44, which is the FTA. That's all for the state.
2 things. What was the recommendation for the registration?
90 days, credit for time served 12 days, concurrent with count 2.
All right, so it's concurrent with count 2. And this is his second DUI conviction, so his license is going to be suspended. What is the purpose of the interlock ignition device?
Your Honor, the state was just doing that out of an abundance of caution in case he is able to regain his license at any point.
I'm going to require a mandatory suspension for 12 months.
Then the state will remove that criteria, Your Honor.
Your Honor, my client says that he was actually detained at Muscogee County for additional 60 days just for this case. He was extradited from that county to Fulton County. He was actually on hold over there for the same charge. However, I was not able to obtain anything in writing yet. It may take a few days for him to get open record, the proof of incarceration.
So do you want to address this case next Thursday then? It won't prejudice his time served.
Yes.
Okay. So position 42 and 43 are reset to June 5th. And once you present proof of time that he has served in Muskogee County, you can present that to Ms. Falk and we can make the adjustment.
Thanks, Your Honor. Thanks, Your Honor.
All right, thank you.
Next is 3031.
This is negotiated plea.
Yeah, Ms. Falk, I'm not sure if I'm doing SAP next Thursday, so if it's not me, please make a note that it's either an interlock ignition device or the mandatory license suspension for 12 months.
Yes, Your Honor, I am making a note in that case right now.
Thank you. All right, this is 30 and 31, Roosevelt Padillo. And Ms. Kim, you've already spoken with him.
Yes, he's
How are we proceeding?
a negotiated plea, Your Honor.
Okay. Roosevelt Padillo is accused of criminal trespass from January 21st of this year, 25 CR 616H. He's got a bench warrant, 25 FTA 1006, from April 2nd, 2025. Mr. Padillo, you've been advised of your right to remain silent, and your attorney is Ms. Kim. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, sir.
I'm sorry?
Yes, sir.
Thank you. Ms. Falk?
Yes, Your Honor, the state's recommendation on the criminal trespass is 12 months, serve 22 days, credit for time served 11 days. That will be from February 5th to February 6th of 2025, and then May 21st of 2025 until today. Balance suspended. Stay away from the Quick Trip at 4745 State Route 138 in Union City. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Yes, we do stipulate.
Mr. Padillo, are we ready?
He's ready.
Have you consumed any medicine or alcohol recently?
I just took a vaccine, tuberculosis, but that was about it.
Are you able to understand what's going on in your case?
Yes, I do. I just have a few questions, but
You can ask.
okay, I will. I see. Thank you.
Shall I proceed, Ms. Kim?
We'll proceed.
Oh, yeah.
Yes,
Are you satisfied with your legal services?
Yes, I am.
And if you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not go back to a courtroom to have a trial before a judge or a jury. You will also not be able to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Mr. Padillo, would you like me to repeat? Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass at the QT gas station?
Guilty.
Your sentence is going to be 12 months to serve 22 days, credit for time served 11 days, balance suspended. You have to stay 200 yards away from the QT gas station at 4745 State Route 138 in Union City. That will include the sidewalk, the parking lots, and the buildings at that property. Thank you. And his bench warrant will be dismissed.
Get that pen, I'll give him the pen right there.
I'm sorry, repeat?
oh, nothing, Your Honor.
Position 39.
Damian Smith is accused of 2 counts of theft by taking from May 2nd of this year, case number 25 CR 24218. Mr. Smith, you've been advised of your rights. Your attorney is Ms. Kim. May I place you under oath for the plea?
Yes, ma'am.
Raise your right hand, sir. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Ms. Falk?
Yes, Your Honor. Can you provide me that case, the position again?
39, case number 25 CR 0024218.
Thank you, Your Honor. On Mr. Smith's case, the theft by taking, the state's recommendation is 12 months served, 44 days, credit for time served, 22 days. That will be from May 8th, 2025 until today. Balance probated. MHET, an anti-theft course, no further contact with Colin Parker. And in lieu of restitution, Colin Parker is asking that his bicycle be returned to him. On count 2, the theft by taking, 12 months concurrent with count 1, no further contact with Colin Parker. And that second portion is amended by the fact that Mr. Parker is asking his bicycle be returned and 40 hours of community service. If Mr. Smith is unable to return Mr. Parker's bicycle, we are asking for restitution in the amount of $250. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would at this time like to sound for Mr. Colin Parker.
Colin Parker, if you're on Zoom, this is the time to unmute and start your video. All right. Ms. Kim, do you so stipulate?
Yes, we do.
All right. Mr. Smith, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your legal services?
Yes.
If you decide to plead guilty to these 2 charges, you would have to give up your right to a trial in front of a judge or a jury. You will not go back to a court of law to face your accuser. The prosecutor will be able to present evidence against you, which you will not be able to challenge. You also will not get the chance to present your arguments and defenses through counsel. The state will also not have to prove the charges against you beyond reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 2 counts of theft by taking?
Guilty.
For count 1, it's going to be 12 months to serve 44 days, credit for time served 22 days. The remainder you'll be serving on probation. You report to probation on Monday, June 2nd, before 3 p.m. While on probation, you will enroll and complete a MH evaluation and submit yourself to any treatment, counseling, and medication as recommended by the evaluator. This evaluation must take place within 30 days of being released. You are also to complete an anti-theft class within 60 days of being released. And you are to return the bicycle belonging to Mr. Colin Parker within 60 days of being released. You can leave the bicycle at a, what is the closest police precinct? Anybody have any ideas?
I know where it is. I just don't know which one.
Let me see if I can find the closest police precinct really quickly, Your Honor.
It can be any precinct near probation, which is at 1 Mitchell Street.
Right.
Right. Okay, yeah, we're still attention. CP calendar on. I'll take you. Okay.
Your Honor, I believe he has Cobb County hold, so he may have to report to the probation officer after he gets released from the Cobb County hold.
Okay. And is it a misdemeanor or felony charge in Cobb County?
We do not know, Your Honor, yet.
Or does your client know?
I believe it's I believe it's a technical probation violation for.
Are you on felony probation or so you got a probation hold?
Yes, it's felony probation. It was transported here to Fulton, but it started out of Cobb.
Then I'm done with this bicycle return because someone has done a screen share or a whiteboard. Okay. Because that while he is on probation hold, I have no idea where this bicycle is, what's his condition, and how the victim will be able to acquire it unless he can disclose his location and the victim goes and gets it.
I can do that. I mean, I can tell you where the bicycle is.
Where is it?
It's at 823 Ponce de Leon Place, and the back of the property. You'd have to go through the alley to get to it, but it's just been sitting there right next to where the U-Haul with this Colin Parker showed up. It probably caused all of this. That's where the bike's been since this happened.
All right, this is what we'll do then. I'll still move forward with a sentence, and Miss Falk, you can get in touch with the victim. He can go to that location and look for the bicycle. If he reports to you that the bicycle has been found and that he's happy with its condition, great. If the bicycle is not found, then the alternative $250 restitution is imposed.
Your Honor, if I may ask, can the defendant give the address again so I can provide that to our victim advocate?
823 Ponce de Leon Place, Northeast, Atlanta, Georgia, 30306.
It's in some kind of alley?
Yes, so Ponce de Leon Place runs perpendicular to the streets Drury and Greenwood. The alley runs parallel to Ponce de Leon Place, if that makes sense. And the U-Haul that Colin Parker, I assume, drove into the alleyway and parked there, along with this bicycle. It's in the same spot where this person came to my house and parked. They knew where to park. I don't know what else to tell you.
Okay.
The victim advocate, that's the best I can tell you on how to find it.
All right, looks like it's a house address.
Yes.
So
Yes, Your Honor, and I provided the address to Miss Cheney so she can provide it to Mr. Parker.
Okay. All right, Mr. Damien, given this 2 charges, are you pleading guilty to them?
Yes.
For count 1 is going to be 12 months to serve 44 days, credit for time served 22 days, balance probated. You will report to the Fulton County Probation within 48 hours of being released from the Cobb County hold or whatever hold you have. Within 30 days, you will undergo a MH evaluation and submit to any treatment that's required. Within 60 days of being on probation, you will complete an anti-theft class and have no contact with Colin Parker. Mr. Parker has been given the directions and address or location of the stolen bicycle. Now, if he reports that the bicycle is no longer there, or if it is found there but in a dilapidated condition, then the court will impose restitution in the amount of $250 to be paid to Mr. Colin Parker within 8 months of being on probation. For count 2, theft by taking, it will be concurrent with count 1 with the additional requirement of doing 40 hours of community service, and he will do the community service at a minimum rate of 5 hours per month while he's on probation. As he's indicated, once he's released from his probation hold, then he will report to Fulton County Probation within 48 hours on the first available Monday, Tuesday, or Thursday. Thank you. Is there a Joseph Smith? Have you done that plea? Position 40 and 41, Ms. Kim? Did we address 40 and 41?
He's not here, Your Honor. He has a private attorney, actually. I was told.
Oh, okay. All right.
Position 33, 34, Mr. Patterson, he refused.
33 and 34. And this is conflict counsel Joe Lewis Brown Jr. Is there attorney Joe Brown on Zoom? No? Okay. We're going to reset this case to June, what was it? June 5th? And Ms. Lewis will need to contact attorney Joe Lewis Brown Jr. to let him know that his client's case is reset to June 5th.
Judge, I'll try to get in touch with, apparently this is on an upcoming jury trial front of Judge Dixon on July the 15th of 2025. I'll reach out to Ms. Cook, who's the litigation manager for Judge Dixon, to find out what's going on with this case.
Can you find out if it's been arraigned? Because if it's been arraigned, we can take it off the SAP calendar.
Yeah, it's been arraigned. It's just been reset for a trial in front of Judge Dixon on July the 15th.
Then it's not reset to June 5th. It's going to move forward to the
I'll
trial.
just put it back to the case manager.
Thank you. All right. All right, so that was for position 33 and 34, and that's moving on to jail jury. Okay, is there a Christopher Carter on Zoom? Christopher Carter, that's our DV bench warrant case.
Judge, that case was dealt with. There's no longer a DV case. Apparently there was an error regarding about the bench warrant, so all that was taken care of, so
okay.
No longer.
Okay, so let me just go down the SAP calendar, then we'll begin with our competency cases. Position number 1, that was null pros. Position 2 was a plea. Position 3 and 4, Bess Mera was released. Position 5 and 6, oh, that's Bess Mera 2, that's released. And so these 4 cases are further notice. Position 7, Keandre Bennett is a waiver of arraignment and further notice for trial. Position 8, Ramita Daniel was a plea. Position 9 and 10, Shamira Davis, that's Miss McLeod's case.
She was released.
She was released, Your Honor.
Okay, thank you. Position 11, Denson was the plea. 12 is null pros. 13, Irvin, and that is a plea. I mean, sorry, that's not a plea. That case has been arraigned and further notice, and the bond has been amended. All right, and then position 14, Candaya Florence is reset to June 5th at 11 a.m. competency calendar. Position 15, Dominic Gay was a plea. 16 was a waiver of arraignment and further notice. 17 is a waiver of arraignment and further notice. So is 18 as well, waiver and further notice. 19, Jules is reset to June 3rd, 2025. Position 20 and 21 are waivers of arraignment and further notice for trial. Position 22 was a plea, 23 is null pros, 24 is a plea, 25 and 26, Carlos Moore was released and further notice. Position 27, Eric Mosley was a plea. And 28 was null crossed. 29 is reset to SAP on June 3rd.
That would be an add-on.
I'm sorry?
That would be an add-on for Tuesday calendar.
Okay. 30 was a plea and 31 was null crossed. 32 is a plea. 33 and 34 is a waiver of arraignment and further notice for trial. Excuse me. Yeah. No, that's already been arranged, so it's just further notice for trial. That's right. Okay. 35 Richardson is reset to SAP on June 5th. 36 Shelby is a waiver of arraignment and further notice for trial. 37 Shields is a plea and 38 is null crossed. 39 is a plea. Position 40 and 41 Joseph Smith, those are going to be reset to June 5th. Whoever's private counsel needs to be notified to let them know about his client or her client. 42 Thomas is 42 and 43. Thomas is reset to June 5th for defense to determine whether additional time should be credited from Muskogee County, and with a note that this will be a mandatory 12 months license suspension. 44 Pasha Thomas and 45, these are further notice. Mr. Thomas was released. Nicholas Walker, 46 and 47 was released, so that's further notice. And 48, Wilkerson was a plea.
Excuse me, Judge, position 40 and 41, y'all saying it has a private counselor? May I ask who that may be?
Do you know who the attorney is? Joseph Smith.
It was John, give me 1 second, mine got,
I have,
You're not showing an entry of appearance, Miss Lewis?
I'm about to double check unless it was not recorded. I see a waiver of arraignment, not guilty, entry on January 18, 24. I'm trying to see, okay, I see the attorney. Apparently it was not associated to the case. I'll make sure that gets done.
What's the name?
I said Jonathan R. Melnick.
Okay, Jonathan Melnick. Okay.
Yeah, I'll make sure that get associated. Apparently was not associated.
Okay.
So get noticed. But he waived arraignment. I think this case was a bond forfeiture case. That's why.
So he's filed a waiver of arraignment?
He had filed a waiver of arraignment back on January 18 of 2024. And it was reset for a jury trial in front of Judge Besson and on January 13 of 2025. And I guess the FTA, the defendant FTA on January 13 of 2025. And that's why we have it on the calendar now.
Okay.
But I will make sure the attorney information is associated with the case because apparently it was not associated.
So let's reset it to June 5th because of the FTA, and we'll let Mr. Melnick appear. Okay?
Okay.
Thank you. Any other questions? All right. Mr.
I apologize, but Your Honor, 4243, if he has a 60 days from Muskogee County, I believe that he can be released immediately. So can we reset this to June 3, 2025, next Tuesday?
We are pretty stacked for June 3rd.
Okay.
It'll be tough.
Yeah,
Okay.
I'm getting ready to do it. I really don't want to do an add-on counter to tell you the truth.
I'm just looking at it. We have 49 out of 35 positions, so we are way over.
Yes.
Okay?
Thank you, Your Honor.
And any other questions? Okay. Mr. Bartel, good morning.
Yes, good morning, Judge.
And for what has been many moons, we're actually beginning a competency calendar at 8 a.m. Okay.
Welcome back, Judge.
All right. I have a Donovan Thomas on Zoom. Mr. Thomas, please remove your head and unmute your screen. Which case are you here for?
Dontavius Thomas.
Is that on our 11 o'clock calendar?
9 o'clock, ma'am. I'm not sure, actually. He told me it was 9. I'm not sure.
Graduation party. Great.
And what's your relationship to Dontavius Thomas?
I'm his father.
Okay. I don't have a Dontavius. Pasha Thomas. Anthony Leonard Thomas. Do you have a case number, Mr. Donman Thomas?
No, ma'am. I just talked to him over the phone. He told me he went to court today. His name is Dontavius DeAndre Thomas.
Okay, may not be in, is that quorum 2? Is that Dontavius Thomas? All right. Mr. Thomas, are you familiar on how to use the chat feature?
No, ma'am.
Your Honor, I believe I can provide some information on this.
Okay.
It appears as though Mr. Thomas's case is in the DA's office under 24 PI 004547. And so I believe the hearing that he's looking for is a felony hearing. I can provide him with the number of the district attorney's office, and he can call them for further information.
All right, Mr. Thomas, this is State Court of Fulton County, and we do misdemeanor cases. You've gotten onto the wrong Zoom session.
Wait, ma'am. He was out on bond for a state case, and it was a signature bond. He didn't go to the place to report, and they picked him up for failure to.
What was the charge?
It was prowling and possession of cocaine.
Okay, that's a felony charge, possession of cocaine. You are in the wrong Zoom session. I don't have jurisdiction over Mr. Dontavius Thomas's case. You have to be in the Superior Court of Fulton County. This is court. So Ms. Falk is going to send you in the chat a phone number. Once you receive that phone number, write it down somewhere and then call that number for the Zoom link.
Okay. All right.
Mute your screen. Thank you.
All right. Thank you.
And Mr. Thomas, you should have that number in the chat now.
Okay. I see it. Thank you.
Thank you.
Okay. All right. Miss Grace, if you can please. Oh, I'm sorry. Are we dealing with a plea from the 11 a.m. calendar? Mr. Bartell?
There are 2 that I sent to PD Bartels. I would just need his announcement if those are ready to go forward.
Yes, good morning, Your Honor. Yeah, on Ms. Riles, number 14, I believe that'll be a negotiated plea. I think there may have been a typo in one of the counts. Ms. Falk, you had, I think on the third count, 90 days, and it was 84 days on the other.
Hold on, let me take a look at that, Riles.
And I'll send this Francois text so they can bring her out.
And what about the other case?
Mr. Sullivan, Your Honor, is here right next to me. That is number 17, and I believe that'll be a non-negotiated plea.
Okay.
And I just was able to talk to Mr. Rogers, who is in the courtroom now. He is number 13. I believe he is able to enter a plea. I haven't asked Ms. Falk for an offer yet because I got a chance to talk with him now. I believe it should be a time served plea or close to it. If you could let me know about that, Ms. Falk.
Or just give me a moment, and you are correct. I adjusted the time on counts 1 and 2 of Ms. Riles' case, but neglected to do so on count 3. So that would be the same 82 days, I believe. Credit for time served, 41.
Right, that's my count. Thank you.
All right. While we are waiting for Ms. Riles' case and for Mr. Bartell to speak to on the matter with, did you say with Mr. Rogers?
Mr. Rogers, Your Honor, that's correct.
Let's go ahead and address, well, I have a court reporter on Zoom right now. we can address Mr. Sullivan, physician number 17.
Okay.
This is State versus Harold L. Sullivan, case number 25 CR 002902G. Mr. Sullivan, my name is Judge Law, and we are addressing this particular case. You are charged with 5 misdemeanor offenses: criminal trespass, interference with possession, loitering and prowling, 1 count of willful obstruction of a law enforcement officer, 1 count of simple battery against an officer, and public drunk, stemming from a November 11th, 2024 incident. Mr. Sullivan, you have a right to remain silent. Anything you say during the course of this proceeding, your statements can and will be used against you. The only time that you'll be required to speak is if we move forward with the plea hearing. You would have to answer some of the court's questions. You have a right to an attorney. If you cannot afford one, Mr. Paul Bartel will be representing you. Right. This is going to be a non-negotiated plea. That means the prosecutor is going to give one recommendation and your attorney is going to give a different recommendation. I will make a decision as to which recommendation I will accept before you proceed. For purposes of this plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Fulk?
Your Honor, out of curiosity, PD Bartels, what is the non-negotiated portion of this?
We're just asking for time served. He's been in for 200 days as of now. He did indicate to me that he was not taking his medication at the time this occurred, which I think, and of course, with being in for 200 days, he doesn't have any income. He's going to have to start his life all over again. And I would just ask for time served.
Okay, so when you say time served, you mean no additional probation?
Yes, ma'am.
Okay, understood. All right, Your Honor, this case involving Harold Sullivan, the state's recommendation on count 1 was time served 200 days, credit for time served 200 days. That is from November 11th, 2024 until today. Count 2 will merge with count 1. Count 3, the state's recommendation is 12 months consecutive with count 1, a $300 fine, 12 weeks of anger management, and ADET. Count 4, the simple battery, will merge with count 3, and count 5, we are requesting time served 200 days, credit for time served 200 days. The reason for the state's recommendation of additional probation, this case was initially in the DA's office as a felony obstruction and was reduced to misdemeanor obstruction and sent to our office. The defendant currently has 14 cycles. That includes this case. His most recent arrest prior to this case was a criminal trespass in September 27th of 2024. He also was sentenced under 24 SC 002462 for robbery. He was sentenced under the First Offender Act and is still on probation on that case. He also has a 2019 failure to appear, a theft by shoplifting conviction from 2019, a criminal trespass conviction from 2019. Let's see, a theft by shoplifting conviction from 2012, which he received 12 months probation, a probation violation from 2011, a theft by shoplifting, a different theft by shoplifting conviction in 2012, where he received 12 months probation, and a 2011 driving under the influence of alcohol and endangering a child by driving under the influence of alcohol, where he received 12 months, 24 hours of confinement and a $1,500 fine in 2011. He also has a cruelty to animals from 2009, where he was sentenced to 12 months probation. As far as this case, Your Honor, the officers were called out to 880 West Peachtree Street Northeast in Atlanta in reference to a individual spraying a fire extinguisher in the parking garage while continuing to loiter around the garage. Officers arrived at the scene. They saw the defendant. He immediately tried to hide. He began talking about irrelevant and kind of nonsensical things, such as being in Paris, and instead of responding to the officer's initial questions. They did try to then at that point take him into custody when he started running away from them. He then started struggling with the officers in the struggle and in the melee of them trying to place him under arrest. One of the officers was injured. The elbow to the officer was bruised and swollen. The reason I believe the case was transferred was because the defendant apparently was not actually striking the officer when this happened. It happened while the defendant was trying to get away from the officers. They also did obtain some video footage of the defendant spraying the fire extinguisher within the parking garage. The defendant also had an open out bottle of alcohol during the time of their encounter with him, which was also the basis of their charge for the public drunk. Your Honor, the state is concerned about the fact that there is alcohol involved in this. I understand that he was not taking his medication, but certainly alcohol intoxication does not help that situation, along with the fact that the defendant has had open cases and is currently showing on probation for that robbery case in 2020. The state does have some concern. That is all for the state, and we do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
Mr. Bartel, what is the issue with probation for ADT and anger management under these circumstances?
Well, as I said, Your Honor, he spent 200 days in jail, which is more than time served on a misdemeanor charge. He has more than paid his debt to society, and he is going to have to be starting his life over again after being in jail for 200 days. I'm told he was in East Georgia Regional Hospital. He initially came back as not competent, but the most recent evaluation was this month, and he did come back competent. Given the amount of time he has spent in jail, I would say that he has more than paid his debt to society. However, I've advised him that it's up to the court's discretion, of course, in terms of what the sentence will be. It looks like the conditions that are being requested by the state, there's a $300 fine, 12 anger management classes, and the ADET. If the court is inclined to put Mr. Sullivan on probation, I would just ask that the only condition be ADET. I can see that would be an appropriate condition of probation in a case like this. With the anger management classes, again, he was just off his medication. He is on it now. And I think the $300 fine would be an excessive penalty given the amount of time he's already been in jail. So that's all from defense. We do so stipulate for the purposes of a plea.
And Your Honor, I just want to point out the $300 fine is statutory for willful obstruction. I also want to point out the defendant was here with us on 24 CR 006738C. He was part of the 11 a.m. calendar at that time. The state entered a null pros on that case on November 7th, 2024. He was arrested 4 days later.
And Your Honor, I think with the fine, I do understand that is in the statute. I think that fine can be suspended.
Well, I don't have a problem suspending the fine. My concern is that I'm not sure about other jurisdictions, but Mr. Sullivan was arrested on February 1st of 2024 and then served 47 days for robbery by sudden snatching, and then was released on June 26. Less than about 3 months later, he came back to the jail on a criminal trespass charge and got released after spending 42 days in jail. And Ms. Falk is right. 4 days later, he came back to the jail again for this particular charge.
Judge, ma'am, I had just lost my parents, my grandmother and my grandfather. I was raised with my grandparents, and they're no longer.
Fine, but people moan and they cry and they move on, but they don't go and create a ruckus where you keep coming in and out of jail.
I didn't have stability.
I'm all sympathy for your loss of family, but you moan and you cry and you eat ice cream, but you don't go and create a ruckus in a public scene.
I believe he was off his meds during this entire time.
So that is a more realistic response. You are in jail because you voluntarily went off your meds. So I'm going to require you to be on probation, just to make sure that you don't come back to jail. This, taking time off from jail is not vacation.
Yes, true.
He indicated he wants to go forward with the plea, Your Honor.
Okay. And if I'm not incorrect, this would be pleading guilty to criminal trespass, interference with possession, willful obstruction of an officer, and public drunk, correct?
That's correct, Your Honor.
All right. Mr. Sullivan, have you consumed any medicine or alcohol recently?
No alcohol, medication for my mental illness, yeah.
Okay. And after consuming the medicine, are you able to understand what's going on?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
And after talking to your attorney about the waiver of rights and the requirements for probation and so forth, are you still moving forward freely, willingly, and voluntarily?
Yes, ma'am.
If you decide to plead guilty to the 3 charges out of the 5 charges that were originally brought against you, you would have to give up your right to a trial in front of a judge or a jury. You will not go back to a court of law to confront your accuser, challenge the evidence brought against you, be able to present your legal defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass causing interference with possession, willful obstruction of a law enforcement officer, and public drunk?
Guilty, Mrs. Young.
For the criminal trespass, your sentence is going to be time served to serve 200 days, credit for time served 200 days. For the public drunk, your sentence is going to be time served 200 days. For the willful obstruction of a police officer, is going to be 12 months to serve 200 days, credit for time served 200 days, balance probated. You'll be on probation to enroll and complete an alcohol and drug evaluation and submit yourself to any treatment that's required. If it's determined that you do not have an alcohol substance abuse issue, then your probation will be terminated. While you are on probation, you will also make sure that you're compliant with all mental health treatment, medication, and treatment and counseling. You are also to stay away from 880 Peachtree Street in Atlanta, Georgia. Do you understand?
Yes, ma'am.
Okay. Now, the sooner you're done with your alcohol and drug evaluation, the better it'll be for you, because if the evaluator said no treatment's required, that's fine. And then your probation will terminate. But if treatment's required, you'll need to make sure you comply with the treatment as well as your mental health treatment and medication.
Thank you.
Yeah, we would ask if the court would consider waiving the first 2 months of fees.
I will waive probation fees for the first 2 months.
Thank you, Judge.
All right, Deputy Francois, this would be Miss Riles.
That is correct. Thank you, Judge.
All right, and Mr. Bartel, do you need to speak with her?
Yes, I've already spoken with Ms. Riles about a plea, but Ms. Riles, the requirement that the state is asking for with probation is the 12 anger management classes, and that's it. Okay, do you want to go forward?
Yes, sir. Yes, yes.
Okay.
All right, then let's proceed with Veronica Riles. Ms. Riles is accused of criminal trespass, simple battery against an officer, and terroristic threats and acts from April 18th, 2025. Her case number is 25 CR 002082D. Ms. Riles, my name is Judge Lal. I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Paul Bartel. May I place you under oath for your plea?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Falk? I'm sorry, please unmute.
Thank you, Your Honor. On Ms. Riles' case, the state's recommendation is going to be on criminal trespass, 12 months, serve 82 days, credit for time served 41 days. That is from April 19th, 2025 until today. Balance probated, concurrent with count 3, and there is a stay away from the smoke shop located at 907 Martin Luther King Jr. Drive in Atlanta, Georgia. Count 2, the simple battery against a police officer, will be 12 months, serve 82 days, credit for time served 41 days. That is concurrent with count 3, and 12 weeks anger management. On the terroristic threats and acts, the state's recommendation is 12 months, serve 82 days, credit for time served 41 days, balance probated, stay away from the smoke shop as listed above at 907 Martin Luther King Jr. Drive in Atlanta. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
We do so stipulate, Your Honor, and we would just ask the court to accept the.
All right. Mr. Bartel, can you hear me?
I can, Your Honor.
All right. Ms. Riles, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your case?
Yes, Your Honor.
Are you satisfied with your services, legal services?
Yes, Your Honor.
If you decide to plead guilty to these 3 charges, you would have to give up your right to a trial in front of a judge or a jury. You will not get the chance to confront your accuser, challenge the evidence brought against you, present your own legal arguments and defenses, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to criminal trespass, simple battery against an officer, and terroristic threats and acts?
Yes, Your Honor.
How do you plead? Guilty or not guilty?
Guilty.
Your sentence for the criminal trespass is 12 months to serve 82 days, credit for time served 41 days, balance probated. Count 1 will be concurrent with count 3, and you'll be required to stay away from the smoke shop at 907 Martin Luther King Drive in Atlanta, Georgia. And that would be the same sentence for count 3, terroristic threats and acts. For count 2, simple battery against a police officer, your sentence is 12 months to serve 82 days, credit for time served 41 days, concurrent with count 3, and you'll also be required to do 12 anger management classes. I will waive your probation fees for the first 3 months. The sooner you're done with the anger management classes, the sooner your probation will terminate.
So that'll be terminated probation once that's completed, Your Honor. Okay. All right. Thank you, Judge.
Okay, appreciate it.
Thank you, Francois. That was done. Okay, so the only other matter for possible plea, Francois, we are done. Did you have any questions?
No, that's it. Thank you, Judge. So just to make sure, so that I can explain it to her as well, this has to do with anger management.
Yeah, she'll be on probation. Once she's released, she has to go to the probation office on Monday, June 2nd, before 3 p.m. And the sooner she's enrolled and starts her anger management classes, the sooner her probation will terminate. She needs to do 12 weeks.
She needs to do 2 weeks of what?
12 weeks of anger management classes.
Okay. Thank you, Judge. I'll make sure she understands.
And her probation fees are waived for the first 3 months.
Your Honor, if I may just have a moment to make the recommendation on that remaining case.
Okay, thank you, Francois. We're good.
Okay. Thank you, Judge.
All right, the remaining case is position number 13.
Yes, Trambus Rogers.
Okay.
If Your Honor could give me about 2 minutes, I should be able to send PD Bartels that recommendation.
All right, we'll take a 2-minute 3-minute recess. How's that? And,
Thank you.
Thank you. We have no internet, so I'll just have to check my phone.
Okay.
Okay. And I'll put it in the chat as well, for courtroom 2, PD Bartels. that'll make it a little bit easier.
Thank you.
Your Honor, I've sent the recommendation to Your Honor, Ms. Lewis and PD Bartels. I just believe PD Bartels will need a moment to go over the recommendation with his client.
All right.
Mike,
Live.
the mic is hot.
Mike, the mic is hot.
I'm gonna close.
Mr. Bartel, we good to go?
Yes, Your Honor. Can y'all hear me?
Yes.
Okay, he'll accept that offer, Your Honor. We're ready to proceed.
Okay. This is position 13 on the 11 a.m. calendar. State versus Trembus Dave Rogers, case number 25 CR 002852D. Mr. Rogers, my name is Judge Law. Please remember you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Bartel. You were originally accused of criminal trespass and disorderly conduct on May 19th, 2025. And I understand this is going to be a plea hearing, so may I place you under oath for the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up, please.
Yes, Your Honor.
Thank you. You may put your hand down. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case on the criminal trespass is 12 months, served 20 days, credit for time served 10 days, balance suspended. That is a stay away from Grady at 80 Jesse Hill Drive unless for medical treatment. Count 2 will be time served 20 days, credit for time served 10 days. The 10 days would be from May 19th of 2025. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We do so stipulate, Your Honor, and we would ask the court to accept the agreement.
All right. And this was to serve 20 days, credit for time served 10 days, balance suspended, right?
Yes, Your Honor.
Right. And Mr. Rogers, have you consumed any medicine or alcohol?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
Yes, Your Honor.
Has it been explained to you that if you plead guilty to these charges, you will not have the opportunity to go back to court to have a trial in front of a judge or a jury? You will not confront your accuser, challenge the evidence brought against you, present your own arguments and defenses, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to disorderly conduct and criminal trespass?
Guilty. I plead guilty.
Your sentence for the trespass is 12 months to serve 20 days, credit for time served 10 days, balance suspended. You have to stay away from the Grady Hospital at Jesse Hill Drive. You can only return to the hospital if you have a valid appointment with a designated healthcare provider like a doctor or some other specialist, or if you are seeking emergency medical treatment. And in either event, you're not allowed to have any violent contact with the staff and the folks at Grady Hospital. Do you understand?
Yes, Your Honor.
All right, it'll be the same sentence, concurrent for disorderly conduct. Thank you.
Thank you, Your Honor.
All right, I don't believe we have any other pleas. Ms. Lewis?
Yeah, excuse me, Judge. The iPhone that's on the Zoom is requiring about information about Anton Park. I don't know if that's the victim in the case. I remember we were talking about restitution. That was position number 32 that was on the SAP counter.
Okay, the person on iPhone, you need to unmute and start your video. Also, this other, oh, sorry, yeah, iPhone, just iPhone. Are you driving?
Can you hear me?
Are you driving?
No, I'm parked.
And what's your name?
Chelsea Hamilton.
Miss Falk, is that a alleged victim you're familiar with?
No, Your Honor. Let me just go back and double check.
Who is the
No,
defendant?
she is not she is not the victim we have listed. That's Mr. Butler.
And Miss Hamilton,
No,
who is the
I'm not
defendant? Who is the defendant that you're interested in addressing?
Antoine Parker.
Ma'am, are you a friend of the defendant, or are you do you have an actual interest in the case? In other words, are you a participant or a witness in the case?
I'm his wife, but I received a text, so I just was following up. I just
So-
see received the Zoom call link.
So just to let you know, Mr. Parker entered a plea today and should be released if he has no additional holds within 24 hours.
Okay. Is it okay for me to ask questions about the case or?
Please contact the Victim Advocate's Office.
Well, actually, Your Honor, she would need to contact the Public Defender's Office since she is
that's
not a witness or a victim in this case. The Public Defender's Office, ma'am, can help you answer any other questions that you may have. I'm not sure who Mr. Parker's attorney was.
PD Kim.
Let me just go back and double check.
It was PD Kim.
Okay, you would be looking to speak with Miss Kim.
Okay.
Okay?
All right.
All right,
Thank you.
thank you.
Mhm. Okay, let's see now. JCS, you're free to go. Mr. Nixon, you're free to go unless you'd like to stay for the competency calendar. ACD is free to go. And Miss Grace, if we can stop the live stream and the recording. Otherwise we just have court staff. Miss Howard, you're free to go because nothing is going to be reported for this next calendar.
Ms. Lewis, should I send the paperwork to you today? All right, thank you.
Right. Probation.
Thank you, Judge Law.
All right, thank you. Probation, you're free to go. And yeah, live stream is stopped as well. Live stream has to be stopped too.
Yes, ma'am.
Thank you. Well, Mr. Bartel and Ms. Fall,